Hey, this is Trent Cotney, CEO of Cotney Attorneys and Consultants, and this is another Cotney Industry Update. We're going to get you all the legal, safety, and HR news you need to know in 5 minutes or less. Okay, first thing I want to talk to you about is increased litigation. We've seen a lot more lawsuits filed as a result of COVID-19, and a couple of cases in particular that I saw over the last couple of weeks I wanted to mention to you. The first is a federal case up in the Northeast. It involves Legal Seafoods. They were the plaintiff. They sued their insurer under an all-risk insurance policy, and in it they were saying, look, we suffered all these damages as a result of shutdowns. You should cover this. Okay, the judge in that case said, no, we're not going to do that because there is no physical harm. Okay, and that's been a consistent theme that I've seen in every single one of these insurance type cases. What is interesting in this case is they brought another claim and they said, under our insurance policy, if we are shut down by a civil authority, then there might be some potential coverage there. The judge said, no, I'm not going to buy it because even though you couldn't have dining room access, you weren't completely shut down. Okay, very interesting case there, a lot of nuances. I do expect some additional appeals and other decisions on this type of issue, but yeah, definitely going to be heavily litigated. Second thing I want to mention to you is a case out of San Francisco. Okay, this was a plaintiff that filed suit against California OSHA. Okay, and they filed it seeking injunctions against the emergency temporary standards that Cal OSHA enacted November 30th, 2020. Okay, the judge in that case said, yeah, I understand that you're basing this off procedural issues and everything, but at the end of the day, this was a significant risk to health and safety, and we think Cal OSHA was justified in doing what they were going to do. So interesting here, you see a direct challenge against the safety agency, and a judge siding with safety at that juncture. So I anticipate that you might see more of this, but definitely interesting trend as far as safety and lawsuits. More on that coming up. Next thing I want to mention to you is a stimulus plan. Okay, it looks like it's a go right now, $1.9 trillion. House has passed it, Senate has passed it. It's not fully through yet, but it looks like it will be. Interesting things in there. Obviously, extended unemployment benefits, another $300 a week, through September. Some relief for restaurants and small businesses, some more money being applied, a grant program. Best thing, though, for the construction industry is that the $15 minimum wage was removed. Okay, that is a good thing for the construction industry. Will it reappear later? Possibly, but it is not part of the current stimulus plan. Okay. Now, I want to talk to you about a couple of things in particular before we end up here. First thing is contracts. I always like to include something about contracts in there. Many of you that are involved in vertical construction, oftentimes you get called out and you're asked to work on an existing building or an existing structure. But after you perform your work, you leave and that structure or whatever it is has changed and is being used for something different. Okay, what you want to do is you want to make sure that you contemplate in your contract that whatever system you are installing, whatever roof or stucco or mechanical or HVAC system that you are installing, that if there is a change to the intended use of that structure, that you are notified immediately. Otherwise, it could void all warranties. This has become a big problem because oftentimes you build something based on a certain understanding of what that building is going to be used for. If that changes, it could put some significant pressure on existing systems and they may fail. So here is a sample provision that you can use. Again, anything in this video, it's educational only. It's not legal advice. If you got a specific legal question, reach out to us, tcotney@cotneycl.com. Last thing I want to mention to you, and I want you guys to pay attention to this because this scares me, okay? The National Council for Occupational Safety and Health, COSH, and its recently published 2021 National Agenda said that it favored the Protecting America's Workers Act, which incorporates a private cause of action by employees against employers for OSHA violations. Okay, what does that mean? Getting rid of all the legalese. What that means is that your employees can sue you under OSHA if this passes for a cause of action, a civil cause of action against you. Okay, now I don't know whether or not right now whether the Biden administration will grab onto that. Okay, it does scare me. So this is something that I think as an industry we need to watch out for, because this will cause employee-related claims to skyrocket. Okay, it's not, in my opinion, it's not the intended design of OSHA to create private causes of action. It should be to ensure safety Okay, so again, stay tuned to this. It's the PAWA, Protecting America Workers Act. This is something to watch out for. As always, I appreciate you guys. Okay, you got any questions for me? You want to hear me cover something else in the future? Reach out to me. You can go to our website, cotneysale.com. Stay tuned for more. Thanks.